This one is funny. Mad in Madison Heights.
I saw that.
And this one is lengthy, so bear with us, everyone, because Mad is calling in and saying, I am currently leasing a home, and I have for the past 15 years, with the intention to purchase it, per the purchase agreement, for the amount of $90,000. In March of 2020, the owners took back that agreement due to income tax issues on the closing date. Now they want to sell the same house with no upgrades for $130,000. My question is, are the owners bound to the original purchase agreement that was signed and notarized by all parties involved back this past 15 years? What can I do to get this house? Mad in Madison Heights. So that was a mouthful. I hope the viewers followed me.
Well, I'd like to see, again, we're going to get into, I'd like to see the documents. Well, I'd like to see the documents, but I also like to know this buyer who's been a renter for 15 years. I mean, my goodness, what did that option say? Because honestly, for 15 years, you're paying rent. You already bought the home, you know.
15-year lease option buy.
Right. So that's intriguing to me, number one. Number two, Madison Heights at 130. Still a great deal, right? I mean, depending on where you're at, but those homes are going for, most of them are going for much more than 130.
Right.
And to answer their question, assuming that this lease option is valid, if all the parties notarize it, regardless of how long it is, if the option lasted for 15 years, the sellers, whatever their excuse, I mean, a tax issue, who cares? They're bound by the option, okay? It's provided that the buyer who executed this lease option met all of the conditions. Again, this is an instance of, like, here we are in a very active seller's market, and a lot of sellers who, 15 years ago, market was still pretty strong then. That's like 2006, 2007. It's before the Great Recession, but, once the Great Recession hit, there were people trying everything they could to liquidate their asset, to sell their home. And they would do these land contracts at low, whatever they could do to get out of an obligation. And now that the market's great, we see so many land contract sellers trying to wiggle out of their deal, and that they made when the market wasn't so wonderful. And they're, I have quite a few for both sides. I mean, I represent sellers and buyers, and but I do see more often than not sellers trying to wiggle out of an obligation that they met, that they made when times were tougher. And so if that individual would send us, and I believe, one of my associates probably already has the agreement, if it's enforceable, we'd be the first people to reach out to that seller, and we call it a demand, and we usually prepare what we call a draft complaint, and we put it all together, and we don't file anything, but we will vigorously, we will write the letter, and not only will we write a letter, but we're going to support it with the complaint that we're going to file against them, like within a very short period of time, if they don't comply with whatever that initial agreement was. That's how we operate, okay? And I don't like when people are taken advantage of, especially in real estate. So anyway, so yeah, I mean, that's kind of an open-ended question. What does the provision say? What if, for 1 second, let's play, we have a couple moments here, a brief moment. What if one of the requirements of the lease option or the option to purchase was that every year the buyer had to, I'll give you an easy one, steam clean the carpet? It's so stupid, but I've seen that, and they don't. Did they meet their obligation? Now, a much more, rigid requirement might be, hey, you got to pay the water bill on time every year, okay, or every month, and they don't. So then you get to, well, what if the seller, under this lease option or purchase option, what if that seller never enforced the provision? There's something called waiver. I mean, there's all these different things. So, if it's waived, do we still have a valid option to purchase? Because if the seller never pushed them and the buyer still ended up paying the water bill, let's say, that they were late on, is that really an incident of default?
Sure.
Did that, you know, the remedies, what are the remedies? Is that default? Does the seller have to actually declare a default for there to be a default? There's so many different things. That's why when people, you know, real estate is almost all contracts. And when we say real estate and contracts, we deal with contracts outside of real estate. But in real estate, everything has to be deliberate in writing. And it has to have professionals. I mean, you're dealing with hundreds of thousands of dollars, professional attorneys who can draft these so that an issue of whether or not there was actually an incident of default. Is that a default that's been noticed? Is it one that's been declared? How is the remedy supposed to be, you know, how can the offending party rectify the default? I mean, there's so many different things, and you wouldn't believe what we go through every day. You know, I have another program coming out. It starts in September, and it's called Real Estate for Breakfast. Did we talk about this or no? Did I tell you this?
Yep.
And all I'm doing is going through forms of what people did wrong.
Yes.
You know, I'm not showing the people, and I'm taking a provision, only giving 5 minutes to it, believe it or not, and telling people, okay, why would you ever sign this document? You wrote this the wrong way. Let me tell you what the problem is. And so in this situation about, again, this is supposed to be a purchase option. I have one where there's a default provision. You can't figure out what the seller's supposed to do or what the buyer's supposed to do when there's a default. It's like a never-ending default provision. It's like, well, if I do this, then it may be default, but who knows? It could be this. And if you do these things and we talk a little bit and we shake hands, maybe I'll rectify the default. Nobody knows what the hell these people are talking about. But guess what? It was an $85,000 problem.
Wow. Ouch.
And the attorney fees, it was 2 years in court. So you can only imagine, because somebody didn't draft it right. So I definitely want to see the document. Getting back to, let's see the document. Show and tell. Let's see it.
Yeah. No, really.
I know,
That's what
Blair, you have nightmares every night after you're done going through these with me. Did I do the document right?
No, it makes me scratch my head sometimes. I'm just like, oh my gosh, better get that right. No, so Mad in Madison Heights. I'm sure you've already turned the documents in today.
Yeah, I think they gave them to us. Yeah.
So,
Yeah.
right. But this is unfortunate. It is an unfortunate situation.
Yeah.
Mostly for Mad, not necessarily the sellers. So.
But when we're done with them,
Mm-hmm.
it may be an unfortunate situation for the seller too.
Mm-hmm. Well, true.